Under Article 143, the law passes acts tending to prevent the meeting of Congress. This is committed when there is a projected or actual meeting of Congress, or any of its committee or subcommittee, constitutional commissions, or the local counterpart, that is the city, municipal, or provincial board or council, and the said offender prevents the said meeting either by means of force or by means of fraud. Under Article 144, the law punishes disturbance of proceedings. Disturbance of proceedings is committed when there is a meeting of Congress or any of its committee or subcommittees, constitutional commissions or subdivisions thereof, or any provincial, city, or municipal council or board. And the offender, while in the presence of such body, will behave in such a manner as to interrupt the proceedings, disturb the proceedings, or impair the respect due it. Then we have under Article 145, the law punishes violation of parliamentary immunity. There are two ways of committing violation of parliamentary immunity. One is punished by prisión mayor, which is committed by any person who by means of force, threat, fraud, or any other means shall prevent a member of Congress from attending its meeting, expressing his opinion, or casting his vote. And the second act of violation of parliamentary immunity under Article 145 is committed when the offender is a public officer or employee, the said offender searches or arrests any member of Congress at the time Congress is in its regular or special session, and the said member of Congress arrested has not committed a crime wherein the penalty prescribed by law is higher than prisión mayor. So we have Articles 143, 144, and 145. So what if there was this, the members of the House of Representatives are all present in the session hall. They were about to vote for the third reading of a new bill. And this new bill would refer to extension of the land comprehension. And many of the farmers from different parts of the country were in the audience. They were in the gallery. Each and every congressman would stand up, explain his vote, whether he votes yes or no to the said proposed new bill, to the third reading of the said bill. And after that, they would explain why they voted yes, why they voted no. It was the time of, let's say, it was the time of the speaker himself. He was stating his vote. He was voting or explaining his vote of yes. Suddenly, a group of farmers from the Visayan region, in one portion of the gallery, about 20 of them, they all stood up. And at the top of their voices, they stated in chorus that they are against this new bill, and thereafter they showed banners. Here comes the head of the security of this said House of Representatives, the security forces. They arrested these 20 farmers. They hold them inside the room, inside the House of Representatives, and thereafter they were cited in contempt by the members of Congress. Can they also be held criminally liable? Are they liable of any crime aside from being cited in contempt by the members of Congress? They're also liable for disturbance of proceedings under Article 144. All the elements are present. Here, these people, by means of force, by means of threat, by any other means, committed the said act because they prevented the said, they performed an act which caused the disturbance of the said proceedings. They behaved inside the said session hall in such a manner that would impair the proceedings, that would impair the respect due these members of Congress. Hence, they are liable for disturbance of proceedings. What if Senator Trillanes was charged with a crime of libel? He was charged with a crime of libel before the Office of the Public Prosecutor, and the Public Prosecutor found probable cause And so the case was filed before the RTC. The RTC also found probable cause. And so the RTC issued a warrant of arrest against Senator Trillanes. The police officers armed with this warrant of arrest went in the halls of the Senate. At that time, Senator Trillanes was delivering another privileged speech. Right after his delivery of the said privileged speech, here comes the police officers armed with a warrant of arrest issued by the RTC of Manila. They served the warrant of arrest to Senator Trillanes and placed handcuffs on him, brought him to the police station. Thereafter, Senator Trillanes posted bail. Are the arresting police officers liable of any crime? They are liable of violation of parliamentary immunity under the Second Act under Article 145. They are liable of violation of parliamentary immunity because they are public officers and they arrested a member of Congress at the time Congress was in its regular session, and the crime committed carries a penalty which is not higher than prisión mayor. The penalty for libel is only prisión correccional in its minimum and medium period, below prisión mayor. Therefore, such arrest will disturb the performance of functions of Senator Trillanes, and for that, the said arresting police officers will be liable for violation of parliamentary immunity under Article 145. But what if, let us say that this member of Congress, or Senator Trillanes, the police officers, when they went to the halls of the Senate, they could not find him. They went to the house, they could still not find him. It is nearing Christmas time. And so they said they will wait for Christmas Day in order to ensure that Senator Trillanes will be in his house. So on the very Christmas Day, December 25, they went to the house of Senator Trillanes in order to serve the warrant of arrest. True enough, it was Christmas Day, there were many people, he was giving gifts, and so Senator Trillanes was there. And the police officers served the warrant of arrest, placed handcuffs on him, and thereafter he was brought to the PNP station, thereafter he posted bail. The arresting police officers were charged with a crime of violation of parliamentary immunity. However, they argued they are not liable. They are not liable of violation of parliamentary immunity because according to them, at the time of the arrest, it was Christmas Day, there was no session in the Senate. Therefore, Congress was not in its regular and special session. Is their argument, is their contention correct? Their contention is wrong. All the elements are present. They arrested a member of Congress, Senator Trillanes, while Congress is in its regular session, and the crime committed is libel, not punishable by penalty higher than prisión mayor. Even if Congress is on break, Christmas break, Holy Week break, any kind of break, as long as the said session has not yet been adjourned for the 1 month period before the 3rd week of July, the start of the other session, still it is in its regular session. Therefore, in this case, Senator Trillanes can file a case of violation of parliamentary immunity against the said arresting police officers. But what if Senator Lacson was charged with a crime of double murder? He went into hiding. Thereafter, he was arrested by the police officer. The police officers were armed with a warrant of arrest. He was arrested. He filed a case of violation of parliamentary immunity against the said arresting police officers. Are they liable as charged? They are not liable. Because although the arrest was done while Congress in its regular session, the crime committed by the said senator carries a penalty which is higher than prisión mayor. It is reclusion perpetuum. Therefore, anytime they can serve the said warrant of arrest issued by the court. Under Article 146, the law punishes illegal assembly. There are 2 ways of committing illegal assembly. First, any meeting attended by armed persons for the purpose of committing any of the crimes punished under the RPC. The elements are that there is a meeting, gathering, or group of persons, whether in a fixed place or moving. Second, that it is attended by armed persons. And last element, the intention is to commit any of the crimes under the RPC. Under this first kind of illegal assembly, the law requires that the said meeting must be attended by armed persons. When you say armed, it doesn't necessarily mean firearms. Arms includes anything that can cause violence and injury. Stones, lead pipes, woods, anything this can be considered as arms. And what is the objective? To commit any crimes punished under the RPC, exclusively under the RPC. The second kind of illegal assembly, any meeting in which the audience, whether armed or not, is incited to commit treason, rebellion or insurrection, sedition, or assault upon a person in authority or an agent of person in authority. The elements are, first, that there is a meeting, gathering, or group of persons, whether in a fixed place or moving. And in this meeting, gathering, or group of persons, the audience were incited to commit treason, rebellion or insurrection, sedition, or direct assault. In the second kind of illegal assembly, the law doesn't require that the said meeting or gathering be attended by armed persons. What will give rise to the crime is the fact that the audience in attendance were incited to commit treason, rebellion or insurrection, sedition, or direct assault. So no need for anyone in presence to have possession of firearms. Both the leaders, the organizers of the said meeting, and the persons merely present there, whether armed or not, can be held criminally liable for illegal assembly. X, Y, and Z gathered about 100 men. The purpose of X, Y, and Z is to incite these men to commit rebellion, incite these men to get out of the street, to uprise publicly for purposes of rebellion. And because of this call of meeting, these 100 men and women indeed arrived in the place. The police officers at the time got a tip that there was this meeting called by X, Y, and Z, and indeed the 100 people arrived. In fact, more than 100 people arrived. The moment they learned of the said event, the police officers immediately went to the place. And there they saw all the people standing up, one of them one by one arriving, and then they saw X, Y, and Z, and the police officers arrested all of them. The police officers filed a case of illegal assembly against all of them. Will the case prosper? The case will not prosper. The first element requires that there is under the first kind of illegal assembly, that there is a meeting, gathering, or group of persons, whether in a fixed place or moving. You cannot call it yet a meeting or gathering. The people are still arriving. Second, there was no mention that it was attended by armed persons. And although the purpose actually of X, Y, and Z was to incite them to commit rebellion, since it was not attended by armed persons, no mention in the problem, they are not liable of illegal assembly under the first act. They are also not liable of illegal assembly under the second act. The meeting, in fact, has not yet started. Therefore, there is no way the audience therein could have been incited to commit rebellion or sedition. Therefore, the police officers' case filed against them, illegal assembly, will not prosper. Let us add facts. Let us say all these people are now CP, and while they were gathered there, X, Y, and Z called on a former member of the military, Colonel W, and Colonel W began his speech. In his speech, he He narrated to the people all the shortcomings of the present administration. And he told the people, it is time to go out of the street and uprise. The president should not continue being the leader of this country. Let the military be the ruler. And so these people were all incited. They shouted, on with the military rule. And they raised their hands. The police arrived based on the tip. The police arrested XYZ, as well as Colonel W, as well as the 100 men and women. What crimes may be filed against them? Are they liable for illegal assembly? X, Y, and Z, the leaders, the organizers, as well as the persons present, the 100 men and women, can all be held liable for the crime of illegal assembly. Colonel W, who delivered a speech in order to incite the people to go out and to rebel against the government, can be held liable for inciting to rebellion. By means of his speech, by means of his proclamation, he incited the people to commit rebellion. And indeed, the people were incited. That's why these people and X, Y, and Z are liable for illegal assembly under the Second Act, because the audience were all incited to commit rebellion against the government. Under Article 147, the law punishes illegal association. There are two kinds of illegal association. An association totally or partially organized for the purpose of committing crimes against the RPC, and the other one is an association totally or partially organized for the purpose of committing crimes against public morals. Under the first kind of illegal association, the purpose of why the said organization was formed was exclusively to commit a crime under the RPC. Under the second kind, the purpose was to commit any crime against public morals. Therefore, it could be a violation of the revised penal code or a violation of special penal law for as long as it involves public morals. Under Article 148, the law punishes direct assault. There are two ways of committing direct assault. First, without public uprising, by employing force or intimidation for the attainment of any of the purposes of rebellion or sedition. And the other one is without public uprising, by employing force, making an attack, or making serious intimidation against a person in authority or an agent of person in authority while in the performance of his function or on occasion of such performance of his function. These are the two ways of committing direct assault. Under the first kind of direct assault, the objective of the offender in the said attack was to perform or to go in order to perform any of the objectives of rebellion or sedition. If there is a rebellion ongoing, if there is a sedition ongoing, direct assault cannot be committed. Although the objective of the offender is to commit any of the acts pertaining to rebellion or sedition, his crime is not rebellion or sedition if there is no public uprising. The crime committed is direct assault. Whether it is the first kind or the second kind of direct assault, the law requires there must be no public uprising. So if in the problem there is rebellion, there is sedition, there is public uprising, and here comes one of the participants attacking a public officer, it cannot be direct assault. Because in case of direct assault, the law requires there must be no public uprising. So direct assault cannot be committed in times of rebellion and sedition, wherein a public uprising is a necessary element. The more popular form of direct assault is the second form. The elements of this direct assault are first, that the offender makes an attack, employs force, makes serious resistance or serious intimidation. Second, that the person assaulted is a person in authority or an agent of person in authority. Third, that at the time of the assault, the person in authority or his agent is engaged in the performance of his function, or the assault was on occasion of such performance of official function. Fourth, that the offender knows him to be a person in authority or an agent of person in authority. And lastly, there is no public uprising. These are the elements of direct assault. First element, that the offender makes an attack, employs force, serious resistance, serious intimidation. Second element, who has been attacked, who has been assaulted. Second element requires he must either be a person in authority or an agent of person in authority. For purposes of direct assault and indirect assault, Article 152 provides those who are deemed to be persons in authority. Under Article 152, the following persons are deemed to be persons in authority insofar as direct assault and indirect assault are concerned. First, any person directly vested with jurisdiction, whether as an individual or as a member of some court or governmental corporation, he is deemed to be a person in authority. A barangay chairman and a barangay captain, he is deemed to be a person in authority. Teachers, professors, persons charged with the supervision of public or duly recognized private schools, colleges, and universities, or lawyers in the actual performance of their professional duties or on occasion of such performance of professional duties are deemed to be persons in authority. How about agents of persons in authority? The same is found under Article 152, second paragraph. Any person who by direct provision of the law, by election, or by appointment by competent authority is charged with the maintenance of public order and the protection and security of life and property, such as a councillor, a policeman, or any person who comes to the aid of a person in authority, they are deemed to be agents of persons in authority. The third element requires that the said person in authority or agent at the time of the assault is either in the actual performance of his duty or the assault was on occasion of such performance of official duty. So there are two situations. If the person in authority or the agent assaulted is in the actual performance of his duty, it is immediately direct assault. There is immediately defiance of lawful authority. The offender knows and sees that this person in authority is performing his function, yet he was assaulted. There is an immediate defiance of lawful authority. But the other situation is that when the said person in authority is not in the actual performance of his function. When at the time of the assault, the person in authority or the agent is not in the actual performance of his function, you have to know the motive, the reason behind the assault. Because the law used the phrase, on the occasion of such performance of official function. Supreme Court interpreted the phrase, on the occasion of such performance of official function to mean that the assault is by reason of, because of the past performance of official function. So if at the time of the assault, the person in authority or the agent is not actually performing his duty, you have to know the reason behind the assault. If the reason is the person in authority or the agent's past performance of his duty, it is still direct assault. If not, it is plain murder, homicide, physical injuries, but not direct assault. The fourth element requires that the offender knows him to be a person in authority, necessarily. Because how can it be said that the intent of the offender is to defy lawful authority when he didn't know that the one he is attacking is a person in authority or an agent? So, he must know that the one he is attacking is a person in authority or an agent thereof. Last element, there is no public uprising. Whenever direct assault is committed and a felony resulted, the person in authority died, the person in authority was injured, you always complex direct assault with the said resulting felony because direct assault is the reason behind the said resulting felony. So it could be direct assault with murder, direct assault with homicide, direct assault with serious physical injuries. You only do not complex it if the resulting felony is only a light felony like slight physical injuries because it is absorbed in the crime of direct assault. circumstances will qualify direct assault if the assault is done with the use of a weapon, if the offender is a public officer or employee, if the offender lays hands upon a person in authority. These are the qualifying circumstances. The first two qualifying circumstances: the assault was done with the use of a weapon, the offender is a public officer or employee. These two qualifying circumstances apply regardless of the victim. Whether the victim is a person in authority or an agent, these two qualifying circumstances will increase the imposable penalty. But not in case of laying of hands, because the law says when the offender lays hands upon a person in authority. Therefore, for laying of hands to qualify direct assault, it must only be done against a person in authority. If the laying of hands is only on an agent of person in authority, the laying of hands will not qualify direct assault. Under Article 149, the law punishes indirect assault. Indirect assault is committed when the following elements are present. First, that a person in authority or agent of person in authority is a victim of direct assault. Second, that someone came to his aid. And lastly, that the offender employed force or intimidation on that person who gave aid to the person in authority or agent of person in authority who is the victim of direct assault. These are the elements of indirect assault. I always give the example of a mayor. Sabi ko noon, the mayor was attending the flag ceremony. Then he was shocked. Nangyari nga sa mayor namin. Diba? Si Mayor Halili namin. Nag-a-attend ng flag ceremony, na-shock from the distance. Na ano daw, sniper daw. O, nasasabi ko, nakatutuloy yung aking example ah. I always give that as example and then, oh, it happened. But in the example, I'm not referring to our mayor. So what if the mayor was inside his office and the mayor was busy signing documents? There was a long pile of documents that he has to sign. And he was busy signing all these documents on top of his table. Then here comes one of his constituents. This person talked to the secretary. He has the so-called medical certificate and he was asking for medical assistance. And so he told the secretary he wanted some medical assistance from the mayor and he wanted to talk to the mayor himself. Even if the secretary gave money already, the constituent said he wanted to talk to the mayor. And so the secretary told this person X to wait for a while and let the mayor finish signing the documents. When the secretary saw that the mayor was about to finish signing the documents, the secretary told X to follow him and they both went inside the room of the office of the said mayor. And the secretary told X to have a seat. The secretary left. The moment the mayor was, the moment the mayor from signing the document looked up to X and told X, "What can I do for you?" X stood up and thereafter stabbed the mayor twice, killing the mayor. What crimes had been committed by X? The mayor at the time, the mayor is a person in authority. At the time of the assault, the mayor was in the performance of his function. Therefore, regardless of X's motive in attacking him, it is immediately direct assault. There is an immediate defiance of local authority because the mayor was in the performance of his function. And it resulted to the death of the mayor. Obviously, the killing was qualified by treachery. Therefore, the crime committed is direct assault with murder. And the offender made use of a weapon. So it will be qualified direct assault with murder. What if the judge has rendered his decision? The judge convicted the accused. After that, the trial for the day was terminated. The judge was on his way home now. The judge was the one driving his van towards home. The moment he turned right on the street, in order to go home, here comes two men on board a motorcycle, the driver and the back rider. These two men immediately went near the driver's seat, and the back rider, with the use of an Armalite, repeatedly fired at the said judge. After that, they forcibly opened the door of the driver's seat in the car, in the said van, and not satisfied, they also fired several times on the head of the judge. The judge died. Later, these two were arrested. And these two happens to be the brothers of X. They were the brothers of X whom the judge had earlier convicted in that day. What crimes had been committed by these two men? The judge is a person in authority. At the time of the assault, he was not in the actual performance of his duty, therefore, determined the motive of the two men. The two men were the brothers of X, the convicted accused. Therefore, the obvious intent was a revenge. Hence, the said judge was shot, assaulted. Because of his past performance of official duty, the crime committed is direct assault. It resulted to his death, so it is direct assault with murder. There was a weapon used, a gun used, so it is qualified direct assault with murder. The teacher saw X, one of the teacher saw X, one of the students, throwing crumpled papers on the other student in front. Why? And so the teacher got mad at the said student. What are you doing? And so the teacher told X, you get out of this classroom. You get out right now. X felt so ashamed. X left the classroom banging the door. Thereafter, X went directly home. Their home was very near the place, the school. And when he went home, he narrated to his father what the teacher had done to him and that he was told to leave. He felt so embarrassed. The father got mad. Why did the teacher do this to his son? And so the father, in a fighting mood, in an angry mood, rushed to the school. As they were going to the school, they passed by the barangay chairman who was talking to some constituents. The barangay chairman saw the father and son and looked at their face and he knew that they would be up to something. And so the barangay chairman followed the father and the son as they entered the said school. And the moment the father and the son entered, the son pointed to the teacher, pointed to his father, the teacher, who told him to leave. Upon seeing the teacher, the father immediately gave the teacher 2 punches on the face. The teacher was caught unaware. It was so sudden. And so he fell on the floor. At that precise moment, here comes the barangay chairman. The barangay chairman tried to pacify and tried to prevent the father from further punching or boxing the teacher. And so the father tried to hold the hand of the said father to prevent the father from boxing the said teacher. When X, the son, saw that the barangay chairman was preventing his father from further attacking the teacher, what X did, he boxed the said barangay chairman. After boxing the said barangay chairman, here comes the security of the school and the security of the school. Both arrested X as well as the father. The teacher suffered slight physical injuries. The barangay chairman suffered also slight physical injuries. What crimes had been committed by both the father and the son? Insofar as the father is concerned, the father attacked the teacher. The teacher at the time was in the performance of his function. Aside from that, the reason for the attack was the teacher's past performance of his function. Therefore, the crime committed is direct assault. Because a teacher, under Article 152, is deemed to be a person in authority in the performance of his function. Therefore, it is direct assault. The teacher suffers slight physical injuries. Slight physical injuries is absorbed in the crime of direct assault. The said father laid hands on the teacher, a person in authority, therefore it is qualified direct assault. What about insofar as the son is concerned? When the son saw that the barangay chairman was preventing his father from further attacking the teacher, the said son punched and backs also the said barangay chairman. So what crime is committed by the said son? Insofar as the son is concerned, the crime committed is also direct assault. The barangay chairman is a person in authority. Even though he assisted the said person in authority who was under attack, since he is a person in authority, since he is considered as a person in authority, he is still a person in authority and not deemed an agent of person in authority under Article 152 because he himself is a person in authority. When he was attacked by the said son X, he was attacking a person in authority, the crime committed is direct assault. And X used his fist, therefore it is qualified direct assault. But the injuries sustained were only slight physical injuries, therefore it is assault. So to summarize, the crimes committed by the father and the son, the father, insofar as the victim, the teacher is concerned, will be qualified direct assault. And the son, insofar as the barangay chairman is concerned, is also qualified direct assault. What if the police officer was manning the traffic? Despite the presence of the police officer, traffic was very heavy. And the police officer at that time has no pistol on his waist. He only was armed with a whistle. One of the persons caught in the traffic was so mad. What kind of police officer is this? He could not ease the flow of the traffic. He has a meeting. And so this man, X, got out of his car, went directly to the police officer, scolded the police officer, "What are you doing? Traffic is heavy. Why can you not ease the flow of the traffic?" And without saying a word, he repeatedly backs the said police officer, unaware. Because of the suddenness of the attack, the police officer slumped on the ground. A pedestrian was crossing the street. He saw the police officer defeated, under attack. He came to the aid of the said police officer, and he prevented X from further attacking by holding the hands of X. X got mad. He kicked twice the pedestrian. Thereafter, he went back to his car. What crime or crimes had been committed by X? Both. Insofar as the police officer is concerned, he suffered less serious physical injuries. Insofar as the pedestrian is concerned, he suffered slight physical injuries. What crime or crimes had been committed by the said X? Insofar as the police officer is concerned, the police officer is an agent of person in authority. At the time of the attack, he was in the performance of his function, therefore, the crime committed is direct assault. And the said act resulted to less serious physical injuries, a less grave felony, therefore it is direct assault with less serious physical injuries. Even if X laid hands on him, since he is a mere agent of person in authority, it will not qualify direct assault. Therefore, the crime committed is only direct assault with less serious physical injuries. Insofar as the pedestrian is concerned, when the pedestrian gave aid to the said police officer, who is a victim of direct assault, the pedestrian remains to be a private individual. And so when he too was attacked by X for giving aid to the police officer and agent of person in authority, X was attacking a private individual. Therefore, the crime committed is indirect assault. And since it resulted only to slight physical injuries, it is absorbed the crime committed is indirect assault. So to summarize, insofar as the victim police officer is concerned, the crime committed is direct assault with less serious physical injuries, insofar as the pedestrian who gave help is concerned, the crime committed is indirect assault under Article 149. The teacher, this was a bar question, the teacher caught a student during the exam cheating. And so the teacher told the student to leave. The student left, embarrassed. The following day, the said student went back to school, found the teacher teaching, went directly to the teacher, and attacked the teacher. At the time this student X was attacking the teacher, another student came to the aid of the teacher, who was under attack. This student tried to prevent X from further attacking the teacher. And so X got mad, he too boxed and boxed. Why? The fellow student. Both of them suffered slight physical injuries. What crimes had been committed by the student X? The teacher, again as I said, is a person in authority. At the time of the attack, he is in the actual performance of his function. Therefore, the crime committed is direct assault. It resulted slight physical injuries, it is absorbed. The offender laid hands on her. Therefore, the crime committed is qualified direct assault. While the teacher was under attack, Y gave help, aided the teacher. When Y gave help to the teacher, a person in authority, under Article 152, Y is deemed an agent of person in authority. So when X also attacked Y, he is deemed attacking a person, an agent of person in authority. Therefore, the crime committed is also direct assault. It resulted only to slight physical injuries, therefore it is only direct assault. He laid hands, but since the said fellow student Y is only deemed an agent of person in authority, the laying of hands will not qualify direct assault. So the crimes committed by X, insofar as the teacher is concerned, qualify direct assault. Insofar as the other student Y is concerned, it will be direct assault. The police officers placed checkpoint along